My name is Ania Fwampo. For now, let's get into the details of the story. And the Supreme Court will today hear 2 lawsuits filed by broadcast journalist Richard Delaskai, a lawyer, and researcher Dr. Amanda Odoi, challenging the passage of the anti-LGBTQ+ bill and its potential assents. This will be the second hearing on the matter, with the first taking place on May 8. The controversial lawsuits have halted the bill from being transmitted from Parliament to the presidency for President Akufo-Addo possible assent. Richard Delaskai, also a private legal petitioner, and Dr. Amanda Odoi, a researcher at the University of Cape Coast, are questioning the constitutionality of the anti-LGBTQ+ bill passed by Parliament. President Nadanko Akufo-Addo declined to receive the bill from Parliament, citing pending cases at the Supreme Court as the reason.
Evidence of such exercise.
Thank you.
As a lawyer, I would say that there's no evidence of such an exercise. My lawyer friend asserts that there was such determination. I would say there's no evidence of such determination.
So sorry. You've heard the broad scope of all the submissions. Yes.
We are vehemently opposed to the application, including the supplemental arguments made in support of it. My lords, the first ground upon which we are opposed to it is that this application is the same application that was previously brought before this court.
I think the submission made by counsel for applicants was that there have been changed circumstances.
I will deal with it.
All right.
I'll deal with it. And my lords, we have deposed to it elaborately in 2 main paragraphs, actually more than that. Paragraphs 11 to 16 of our affidavit in opposition. Paragraphs 11 to 15 of our affidavit in opposition. 20, first one to leave of record, yes. That's it.
It's 11 to
15. My lord's attention is drawn specifically to paragraphs 11 and 12 of that same affidavit. In those 2 paragraphs, we take time to break down the arguments made in the earlier application and compare them to the present application. And we reach the conclusion that it is the same. Now, I'll deal with the additional aspect. It says that the only difference between this application and the previous one is that there has been a continuation of the legislative process, which is that it has reached a different stage. But in the previous application, our answer is simple. In the previous application also, it sought to injunct a particular stage of the legislative process. And our affidavit in opposition attaches the previous application, which merely sought to restrain Parliament from proceeding with the bill. And we say that it doesn't matter that this time you are saying that Parliament should be stopped from transmitting the bill because Parliament is still proceeding with the bill. That is the simple answer to that, this supposed new fact.
So the first time it sought to injunct Parliament from proceeding with deliberating, and this one is seeking to injunct Parliament from transmitting.
Actually,
that's the difference.
Yes, my lady, it doesn't add deliberating. It just says proceeding.
I'm evaluating.
Very well.
So I'm asking you.
Yeah, it only says proceeding, and proceedings could include deliberations as well as continuing with this duty to transmit it to the president. And so it is not a different application. In respect of that application, so in substance and everything is the same. In respect of that application, this court on the 19th of July 2003 made specific findings and held as follows. In fact, an enhanced panel of this court said, we have considered the merits of the application before us. It is our considered opinion that a prima facie case has not been made. So first of all, on the same arguments and substance, the court made the finding that no prima facie case has been made out. The court made a further finding that no irreparable damage has been established by the plaintiff to warrant the grant of the injunction. And I'll go back to some of these facts.
Mr. Sir, before you proceed, I just want a little clarification. Yeah. Are you saying that we are bound by this interlocutory decision?
You should generally be bound by it, especially that it was an enhanced panel of the court.
Is that the position of the law, that in interlocutory matters we are bound by a decision?
Well, my understanding of the position of the law is that the court is bound by its decisions on principles of law. And if the court decides that in interlocutory matters it's not bound, I will at least persuade you with it, because I don't see that distinction clearly in my reading of the Constitution.
From what you are saying, you appear to be urging us to consider ourselves bound by this decision. That is why I have a little problem.
Yeah, maybe let me urge.
Because if there's a principle of law that you want us to be bound by,
yes,
then please articulate that particular principle of law from this decision.
Very well.
That you think we should be bound by that principle.
I'm most grateful, my Lord. Yes. The principle of law is that the three-way tests established by this court in the so many lopsided decisions of the court in matters like this say, first of all, that you should establish a serious issues of law to be tried by the court. Secondly, you should show that
the just factor.
And the just and convenient. Very well. And this court reiterated in the same case, on the same facts, the same principles, applying it to the facts, which are the same as now. And so if the court even decides that it's not bound by its previous decisions, delivered by an enhanced panel in interlocutory matters, I will urge it on the court that there is nothing new in this case that will justify that departure. I'm most grateful for giving me the opportunity to clarify this matter.
But Mr. Sorry, at that time, Parliament had not completed its work.
At this time, Parliament has not completed its work. Parliament's work includes, after the last full debate under Article 106, to transmit it. That's part of its work, statutorily and constitutionally.
So is Parliament able to return this bill for debate? Further
Absolutely.
debate?
I was going to make that point. And some of the questions that came from the court earlier hinted at that Parliament sends it to the President. The President has options. He has a discretion whether to assent to it or not. The President can return it to Parliament to take into account some of these arguments that they are making in support of their case, to reconsider the bill. The President has that power under Article 106, Clause 7 and 8. Then the President can even refer it to the Council of States for advice on it and tell Parliament that I have referred it to the Council of States. And so this application in the court says, no, we shouldn't even allow the President to decide whether he can engage Parliament on the very issues that his principal legal advisor could tell him that right now, tell Parliament to do this. They say he shouldn't even get there, so that he will take the advantage of his constitutional obligation.
Mr. Sorry,
yes.
Let's be on the same page. If I understand, and I think I do, the applicant and the Attorney General.
Yes.
In fact, the Attorney General presented an enhanced position.
Yes.
The Attorney General identified, or the applicant said, that there has been a violation of the Constitution. It started when the deliberations started without the fiscal impact analysis.
Yes.
And that violation more or less was completed when Parliament got to the end of its work without still having the benefits of the fiscal impact analysis. And then he also pointed out that even in the submission that there had been the consideration required by Section 100 of the of Act 921, what you attached is an extract of the LI, but not a fiscal impact analysis.
Yes, ma'am. Valerie.
If I may come,
Sorry.
if I may come,
Sorry.
Then the Attorney General went on to say that there were two acts within the genre of Article 21B Acts. And these two acts is that one, the person presiding did not make a determination. And that determination should be made from objective indices. And the second act is that Parliament completed its deliberations, ended with a bill that's ready to transmit without the fiscal impact analysis. So the person presiding did an act or an omission or both, and Parliament itself as an institution did so. I think that that's the submissions that have been laid on the ground.
Yes, my lady. And I said it has always been the same submission. The reason why they came to this court, first of all, was that that determination was not made. That was the point that has always been made, first of all. Secondly, the argument that no determination was made was previously even made by the plaintiff in the plaintiff had in the earlier application said that by failing to expressly state and record the reasons for proceeding with the bill or otherwise, a decision had been made by that. And that, I'm sure that's a question that my lady to your left was asking, that could in other ways, could we will not accept an omission or a conduct that suggests that that decision was taken, except if we see it in writing. And I'm saying that throughout the history of parliamentary proceedings, in respect of the constitutional provisions that reflect this constitutional provision which has caused this suit, the question is whether it is always the practice for the person presiding to make that determination in writing in respect of every bill that comes to Parliament. The practice is that doesn't exist. In any event, I want to look at the rules.
Have you even stated that in your affidavit, that practice that there exists, for them even to have an opportunity to rebut it?
We have.
You are just bringing it out right now and from the bar, and I think that's.
I will answer that. My lord, in the plaintiff's arguments, the plaintiff strayed into the statements of case that were earlier filed, including affidavits that this court had impliedly struck out, and then even ordered me to file the present one on which we are dealing. And I'm speaking from the same statement of case. That very well. My lord said they didn't have it, but I'm responding to that point. And my lord, let me just go ahead and make this point in respect of the provision itself. It's when he made it, actually, my lord said you didn't have it, but I was responding to that. The provision says this: Parliament shall not, unless the bill is introduced or the motion is introduced by or on behalf of the President, proceed upon a bill, including amendment to a bill that, in the opinion of the person presiding, makes provision for. Throughout the submissions, I've not heard the point made about the meaning of makes provision for. The question is that the submission I'm making to the court is this: all that the person presiding is required to do is to find out whether the bill on the face of it makes provision for. That is the meaning of the rule, of the constitutional provision.
So,
how we should,
how does it?
I'm sorry. This is how we should construe Article 108(1).
No, the submissions that we're making all said that it imposes on. It imposes. It imposes. So is their reading, and if you listen to the submissions of even the Attorney General, it is to the effect that it's likely to impose because of the following consequences. But the question is that the constitutional provision?
Is that the
wording of it? That is not its wording. So it is okay if they say it is likely to, or it has the effect of. That I can relate to that argument. But are we still construing the provision or saying that when the court comes to deal with the substantive matter, the court should consider reading it in a particular way to give it that effect? That is a totally different submission. And I am also submitting to the court that let a clear distinction be drawn between an act of parliament that it is alleged has not been complied with, as distinguished from a constitutional provision that has been violated. So it is not right in invoking the court's original jurisdiction, which is to determine whether a constitutional provision has been acted in contravention of, or there has been some conduct that is inconsistent with it, to say that, oh, let's go and understand that constitutional provision by bringing provisions of a statute, which, as we speak, is being litigated by the same parties in the High Court in respect of the fiscal impact analysis under Section 100 of the Act. That matter is before the High Court as we speak.
I'm sorry, you've lost me on the points you are supposed to have made just now.
Yeah, very well.
You would have to reiterate it.
Yeah, very well. So the first thing I said in relation to Article 108 is the fact that all the submissions I've heard so far don't address that key phrase, makes provision for. So does the Act make provision for? And then in response to a question to the Attorney General about private members' bills being introduced, the Attorney General said he recalled one in the past. And I believe the one he recalls is the one that had to do with the Road Traffic Amendment Act. That also included provisions with the likelihood of people going to jail. It was a Private Members Act. It was assented to, and we didn't have these issues. And so, I'm urging the court to follow its previous decision where it laid it down that presumptively the court will not injunct this process, which has not reached a point there's nothing dire in it, because the president may exercise his various options to get what they are doing.